Hello, my name is Matthew Joe, and today I will be discussing the equitable remedy of specific performance in employment and construction project contracts. I will begin this presentation by outlining specific performance and the prerequisites for awarding specific performance. I will then explain how specific performance is applied in contracts relating to construction and employment. Specific performance is an equitable remedy ordered by the equitable jurisdiction of a court and essentially orders a party who is not satisfied their contractual obligations to fulfill their obligations under the contract. It requires the court to supervise the execution of their obligations under the contract, and this limits its availability as a remedy to contractual breach. The best and most common example of a contract in which specific performance can be applied to is one involving the sale of land. As an equitable remedy, there are several things that distinguish specific performance from common law remedies. That is, it is usually only awarded where common law damages are an inadequate means of compensation to the injured parties. They are discretionary. That is, they are not automatically awarded to the injured party once they have proved a breach of contract. Instead, the conduct of both the parties will be examined by the courts to determine whether to award specific performance. In this examination, if the plaintiff seeking specific performance is in breach of their obligations under the contract, or has failed to bring the action in a reasonable time frame, then the court will refuse the remedy. Additionally, there are three essential prerequisites for the remedy of specific performance. That is, the contract must be specifically enforceable, valuable consideration must be given for its performance, and damages must be inadequate. It can be said, though, that there are not any contracts to which the remedy of specific performance would not be available, though this relief has been granted more widely in some situations than others. Two classes of contract in which specific performance are not awarded are the contracts for the lending of money and those awarding the license of land. When awarding specific performance, there are two general considerations. That is, there is fairness to both parties and the satisfying of a supervision requirement. When covering fairness to both parties, the court must take into consideration the fact that it would be unjust to hold the defendant strictly to the fulfilment of their side of the bargain, unless the plaintiff has fully performed all obligations under the contract in dispute or is in a position to carry them out. To determine the overall fairness when awarding the remedy of specific performance, the courts have formulated two tests. Firstly, the mutuality test, where the court will not award specific performance unless it is satisfied that the defendant will be sufficiently protected in the circumstance where the plaintiff does not perform the obligations ordered by the court. And secondly, the exact performance test. As discussed above, the refusal of the remedy of specific performance to a plaintiff who has not performed their contractual obligations unless they are ready and willing to perform them. We now move on to the requirement of supervision. This is the element which directly applies to construction and employment contracts and can limit the awarding of specific performance in such contractual dealings. When awarding specific performance, the court must be satisfied that the performance of the obligations enforced in the disputed contract can be supervised. In this context, supervision is not overseeing the performance of the contract, but rather determining when the order handed down by the court is broken. Orders by the court relating to specific performance are enforced by contempt of court proceedings, and failure to comply with such an order is punishable by fines and in some cases jail terms. This is why the courts are reluctant to hand down the remedy of specific performance in contracts which do not state what performance is required. If the time period for performance is over a number of years, and if the contract involves compliance with complex terms and conditions. In general, specific performance is more likely to be granted where the order requires the defendant to achieve a particular result, such as the transfer of land, rather than orders which require the defendant to carry out an activity such as run a business. We now move on to particular types of supervision in construction and employment contracts. In construction contracts, case law has determined that special principles as to whether specific performance will be ordered they are mainly that the practical considerations are often finely balanced with the high cost of seeking repeated rulings on how a complex construction contract is to be performed and completed. That said, in early case precedents, Lord Justices have alluded to as to how such performance will be awarded and judged. Lord Hoffman, in the Argyle Stores case, stated that it is easier to award specific performance of a contract to achieve a particular result, such as construct a building, rather than to carry on a business. And in the Wolverhampton Corporations against Emmons case, Lord Justice Romer specified 3 conditions for award of specific performance relating to construction. That is, that the contract is precise as to the matters of performance, the plaintiff has substantial interest in the performance which cannot be compensated by damages, and the defendant has possession of the land on which the work is to be done. Moving on to employment contracts, it is the general rule that specific performance cannot be applied to performance contracts, due to a partly moral justification, as equity will not compel one person to work for another